Hello everyone. In the last presentation, we have seen that an agreement enforceable by law is a contract. In order to amount to an agreement, there has to be an offer to do or not to do anything by one party, and the other party has to accept it. Thus, an offer and an acceptance of the offer are the two basic elements of an agreement. By making an offer, the offerer expresses his willingness to do or not to do anything. But mere offer and acceptance may not amount to an agreement. There has to exist an intention to create legal relationship between the parties, and the offer has to be certain. Where A invites B to his house for dinner and B accepts it, it is just a social agreement, and A and B here do not intend to create any legal relation between them. Similarly, where A offers to sell his house to B, A has three houses in the city, but he does not specify which house he intends to sell. Here, the offer made is uncertain and hence cannot culminate into an agreement. Where A only expresses his intention to do something, or where he invites the other party to make an offer, it is not an offer but only an invitation to offer. Display of articles in showcase of a showroom is only an invitation to offer. The person who intends to buy the thing has to make an offer to buy, and the shop owner has to accept it, and only then will there be an agreement. Similarly, a tender for supply of goods or services is an offer. Offer may be express or implied from the conduct of the offerer. It may be made to a particular person when the offer would be a specific offer, or it may be made generally to the public when it is a general offer. The offer has to be communicated to the offeree with an intention that it should be agreed to, and when it is agreed to by the offeree, a contract comes into existence. A offers to sell 10 kgs of mangoes to B at the rate of Rs 50 per kg. When B accepts to purchase the mangoes for Rs 50 per kg, there is an agreement between A and B. An offer should not contain a term, the non-compliance of which would amount to acceptance. Supposing A offers to sell a pen worth Rs 10,000 to B and says that if you don't refuse to buy it in writing within 10 days, you would be deemed to have accepted the offer. This will not culminate into a contract because the offer here is not valid. An offer is terminated when the notice to that effect is communicated to the offeree by the offerer before the offeree communicates his acceptance to the offerer. When an offer specifies the time within which an offer has to be accepted, the offer lapses when the time lapses. When the time is not specified, the offer lapses when acceptance to the offer is not communicated within reasonable time. When the offerer becomes insane or dies, the offer lapses. Where the offeree makes a counter offer to the offerer, the offer lapses. Suppose A offers to sell a watch for Rs 9,000 to B, and B asks A if he is willing to sell it for Rs 8,000. A says no, and B accepts to buy the watch for Rs 9,000. Here, A may refuse to sell the watch to B because, having made a counter offer, the offer made by A lapses. Where the manner in which an offer has to be accepted is prescribed, or where a prior condition imposed in the offer is not fulfilled, the offer lapses. When is communication of an offer complete? When the offer comes to the knowledge of the offeree, that is, the person to whom the offer is made, the communication of offer is complete. When is communication of acceptance complete? When the acceptance is put in the course of transmission to the offerer, communication is complete so far as the offerer or proposer is concerned. So far as the acceptor or offeree is concerned, the communication of acceptance is complete when it comes to the knowledge of the offerer. Revocation of acceptance can be made before the other party accepts and communicates its acceptance. Revocation of acceptance can be made before the acceptance is communicated to the offerer. When the offer contains special terms, they have to be brought to the notice of the other party before the acceptance of offer. Otherwise, it will not be bound by the special terms. If the other party knows about the special terms, they are bound by it on accepting the offer. Regarding rules pertaining to acceptance, the acceptance has to be absolute and unqualified and should be communicated to the offerer within the time specified and in the manner prescribed. The acceptance must be such as to reflect the intention to fulfill the promise. When the offer is made to a specific person, he alone has to give acceptance. But where the offer is general in nature, any member of the public who fulfills the conditions specified in the offer can communicate his acceptance. For example, a company advertises in newspapers that a reward of £100 would be given to any person who contracted flu after using the smoke balls of the company according to the directions. Mrs. Carlyle used the smoke ball but contracted flu. Held she was entitled for the amount because she accepted the offer by doing as specified in the advertisement. Mental acceptance is no acceptance. Acceptance also cannot be implied from silence unless the offeree indicated that his silence means that he accepts. An acceptance may be subject to contract, which means that the parties do not intend to bind themselves until a formal contract is prepared and signed by them. Where the parties agreed to agree in future, there is no contract. Example, where there was an agreement between a company and we that the company would favorably consider an application for renewal of contract, held the agreement was not intended to bind the company to renew the contract with we and hence was not binding on the company. A contract by telephone and telex has the same effect as oral agreement entered into between the parties when they are face to face. In addition to an offer and acceptance between the parties, there has to be a common intention to enter into legal relations. Without such intention, there is no contract. When the agreements are commercial and business agreements, there exists a presumption that the parties intended to create legal relations. In social and family agreements, the presumption is that the parties did not intend to create legal relations. Both these presumptions are rebuttable and can be rebutted by adducing contrary evidence. When the agreement is vague and uncertain, the presumption is that the parties did not intend to create legal relations. Where a husband promises his wife on leaving her that he would pay to her £15 a week so long as he can manage it, it was held that though there could be a binding agreement of this nature between a wife and a husband on their living separately, as here the terms are vague, they indicate that there is no intention to create legal relations. This, in brief, is about rules relating to offer and acceptance as contained in the Indian Contract Act. Thank you.